So a couple of trades coming through and range kind of markets. Mitesh, we'll come back to you with more. We have PV Shiju joining us, managing partner at India Law LLP. Shiju, good afternoon. Good to have you with us here. Thank you for your time. I think we all briefly alluded to the judgment from the Supreme Court. As a sort of IBC specialist, Shiju, what is your take on this? And is there any precedent? What happens from here? What does JSW need to do? Does this asset go back to a newly formed committee of creditors? What's the road ahead?
Yeah, the initial reaction is quite shocking, but at the same time, Supreme Court has reiterated that also the IBC process should be transparent, fair, and also a timely implementation of the plan. These are the basic principles of IBC. So Supreme Court has reiterated that. As far as the whole plan is concerned, the major problem, the Supreme Court has stated that, I have not seen the judgment yet, but it basically does not comply with the legality provisions under the IBC, and also it does not process, it's not a fair or transparent process, and also not providing for a timely implementation of the plan. Only the reason for that, because of the use of the optional convertible debenture route, it is not bringing the money upfront instead of an equity infusion. That is the major reason. And Supreme Court, it looks like, came heavily against the resolution provision and CUC also. So the next ground, yeah, it's very challenging. The whole process has to be revamped. And as far as the JSW is concerned, court clearly stated that is going for a liquidation. So a liquidator will be appointed, a new liquidator will come into play. And basically, he has to put the company through a liquidation. So yeah, JSW is not going to get the assets directly. Only through a liquidation process, anything is possible. That is open for everyone.
But Shiju, what happens to the sunk costs, the investments that JSW Steel has already made in Bhushan?
Basically, I came to know that some sort of statement made by the lawyer earlier regarding how the money will be gone back or will be distributed back. So there was a statement in the court, but that's what I heard, saying that if the plan failed, how the money will be paid back. So it will be clearly written down in the judgment.
Shiju, what happens in the interim? From today onwards, JSW Steel will have to stop operating the unit?
See, basically, since the plan is under the implementation schedule, there will be a monitoring committee already. So the monitoring committee will be continuing till the liquidator will take over the company.
Okay, so that means the plant continues to function, right? According to what you expect?
Not the plan. The company will be kept as an ongoing concern as of now by the monitoring committee. Maybe a resolution plan may be a part of it. Generally, resolution applicant is also a part of the, not applicant, resolution proposal is also a part of the monitoring committee. So till the liquidator takeover, the company will be kept as an ongoing concern. Then liquidator will come into play and he has to sell the assets now. In the CIRB process, the company is sold as a going concern altogether. Now he has to sell the assets of the company, which is even the plant.
And JSW Steel, and when it comes in for liquidation, JSW Steel can be one of the participants?
It can be one of the participants. There is no, because it's there is no disqualification as such. It can participate.
Interesting, because the company does roughly 3,000 crores of EBITDA, and it could be valued at 21 to around 24,000 crores, very, very roughly. And they have already paid 20,000 crores. So, they could be best favorably placed if in case they are allowed to go ahead and bid for this unit. But it's unclear about how they get, how much of the money they can get back and how that is worked out. Guys, you want to take over?
Shiju, I just had a question. Even before we talk about the liquidation process starting, wouldn't you expect JSW to file a review petition? Do you think that route would be open? And since you're saying the problem seems to be using these optionally convertible debentures and not bringing in equity upfront, could that be a possibility that the company says that, okay, we'll bring in the rest of the equity upfront and, please review this judgment? Would you expect that?
Basically, review petition is on a very limited ground. Okay, it cannot just go and say that we'll bring it upfront. It can only go for a review petition on the same bench, saying that there is some apparent error or some technical mistake or some new facts. So review petition ground is very limited, that perspective. Yeah, I believe that the JSW will try to go for a review, but a very limited ground for review.
Would you be, are you a bit surprised, Shiju? I mean, the market absolutely is shocked. So would the business fraternity be, because this was all done. I mean, it was approved at the NCLAT, it was approved by the company of creditors, the money had come in, the plant was up and running. And for this judgment to be coming today, I'm not too sure if this was the court taking some sort of suo motu cognizance, or, I mean, just walk us through how you think this has come about today, because this will make any other ongoing resolution processes perhaps a bit in question as well.
See, as an IBC lawyer, I've been in the IBC since its inception. First, when it came, because JSW takeover of Bhushan Steel, highly contested and very successful resolution process, a success story for IBC, which we desperately needed. So yeah, the first stage it came as a shock to me, even though I know the implementation was delayed. There were a lot of ED issues in between, so it was not completely a smooth road. There was ED attached the property, there was some discussion, there was some issues regarding detachment of the property, then High Court has to intervene. Issues were there. So however, Supreme Court striking down the plan, the first reaction is shocking, but at the same time, I would not completely shocked also, because at a later stage, when I think now, because see, the IBC is not like your M&A transaction where you structure the plan like a real M&A transaction. So it has to be clearly a transparent and timely mechanism where a fair and equitable treatment and a quick resolution is provided. That's what the sole purpose of IBC. So when you do a lot of structuring through OCD, debentures, such instruments, a lot of uncertainty also kicks in. So that is one of the reasons IBC struck down. So in future plans, when you structure, so the participant would be more careful to make sure that the instruments and the structure is very easily and transparently and fair.
Are you, Shiju, are you sure this is the reason? OCD?
The reason OCD is one of the main reasons, because of the Supreme Court. See, basically there are two reasons. One is OCD, then there is delay in implementation. But I have noted that Supreme Court stated that NCLT and COC should not have approved the plan. Such course arises only if the plan itself is per se contrary to the legal provisions.
A lot of the resolutions which are underway, are these instruments involved in other ongoing sort of resolutions? Is it a much used route?
Yes, it is a frequent problem we always see, because there is a tendency to structure and defer the payment through other instruments. So even when we raise certain objection to that as a lawyers and all, but IBC per se does not prohibit that. But
I think this now sets a precedent, right?
Yeah, this
it'll have to be.
So when you use a structure like this, you should be able to clearly justify why it is used. It should not be only for the purpose of deferring the payment.
And you don't see too much of a case of a review petition like you're saying. You don't think that there is a case for it?
I really doubt. I'm very skeptical. I would not say there is no, but I'm skeptical, that's all.
Okay.
We spoke to HP Ranina on this, and he said that you can go to a review petition. I mean, they can go with new facts, and the new fact is that they will now, implement this via the equity route only. So they said the review petition on existing grounds is not possible, not legally tenable. But if you change the facts, that is a new method of completing the transaction that is pure equity, as was earlier planned, then they can go ahead with a review petition. Just one final question, Shiju. Are there any other instances where the implementation was not executed as per plan or within the stipulated timeline? Is there any other case which could face a similar fate?
There are many plans. There are a number of plans which are really delayed.
A lot of sleepless nights then, I think, within the legal as well as in the business fraternity. I mean, these ongoing IBC resolution cases that are going on. Thank you very much, Shiju. Very, very helpful perspective on this. And let's see what the next couple of weeks bring on.